The Associated Press claims it got an internal ICE memo that says immigration officers are asserting sweeping power to enter homes without a judge's warrant. But this may not be entirely accurate. Homeland Security has responded that administrative warrants have been used for decades, and the Supreme Court and Congress have recognized the priority or the propriety of administrative warrants in cases of immigration enforcement. Joining us to break this down is Andrew Arthur, Law and Policy Fellow at the Center for Immigration Studies and former immigration judge. Andrew, thank you for joining us today. So there appears to be some confusion whether ICE needs a judge's warrant to enter the home of an illegal immigrant for deportation. So my question to you is, do ICE officers use warrants currently to enter the homes of illegal immigrants? And what type of warrant is this?
So, Don, at the present time, ICE isn't using warrants to force their way into people's houses. If they show up at the door, they knock. Even if they have a warrant, they ask the person to come to the door. And if somebody consents to, coming to the door, to turning themselves into ICE, there's no issue. What's at issue here is a purported memo that states that ICE can use warrants of deportation. Those are for people who have gone through the legal process, who have received due process, and who are under final orders of removal to, be taken into custody by ICE. And what the memo purports to state is that they can use that warrant of deportation for the person under a final order of removal to enter a house. But, to the best of my knowledge, this memo, this proposal has never actually been done. ICE isn't, banging down anybody's door to take into custody somebody who's under a final order of removal at the present time. But they may be able to.
Okay, can you just explain to us the difference here between these types of warrants?
Sure. So generally, when we talk about warrants, we talk about judicial warrants. Those are warrants that are issued by a judge, either a federal judge in the federal context or a state judge with states and localities, to go and look for a specific person or look for specific items. If somebody has a warrant like that, they have the right to go into a named place in order to find the person, find evidence that they're looking for, find contraband, drugs or a gun or something like that. These are administrative warrants, and administrative warrants have been provided for in the law since 1952. In fact, in a Supreme Court case, Abel versus United States from 1960, if anybody's ever seen Bridge of Spies, it's that Abel. ICE, or the then INS, used that warrant to go into a hotel room to arrest a suspected spy and to take him into custody. And the Supreme Court didn't expressly say that that is completely constitutional, but they also didn't say that it wasn't. And they strongly indicated that, in fact, an INS warrant, the predecessor to ICE, that a warrant issued, an administrative warrant issued by the agency itself, not by a judge, would be sufficient to allow them to go into a private place like a hotel room or a house.
So why are sanctuary cities not responding to some of these warrants from these officers? What's the reasoning here?
So, with respect to the sanctuary cities, you're talking about a different document, and that's an ICE detainer. ICE issues detainers to states and localities, telling them that they would like to take custody of a specific immigrant who is in criminal custody in the state or the locality. Now, if ICE takes custody of those people after they've finished their sentences, which the law requires them to do, then they could take them off the streets, put them into ICE custody, remove them from the United States, and make sure that they never offend again. It's important to note most aliens in the United States aren't criminals, Don, but criminal aliens are, and the average criminal reoffends within 3 years. So, this is a good government thing. It's a public safety thing. But many of these sanctuaries don't comply with those detainers because for some reason they think that by shielding their criminals from deportation, they're somehow protecting immigrant communities. But exactly the opposite is true. Most of those criminals live in immigrant communities. They're going to go back to the immigrant community if they're released and ICE can't pick them up, and they're going to reoffend in those immigrant communities. But honestly, Don, the biggest problem is most state and local, legislators don't really have any understanding of how the immigration law works. they fall for a lot of false promises that are made by advocacy groups, and they do that to the peril of the very immigrant communities they're claiming to help.
Okay, so going back to the type of warrants that are being used, has policy over these warrants changed at all under President Trump?
It has, Don, at least if AP is right about this particular memo. Now, traditionally, ICE never asserted that it could use an administrative warrant to enter somebody's house. Again, that's a policy choice. That's not a legal decision. And if this policy were actually implemented, it would become the policy of the agency to say, show up, knock on the door, ask the person if they'll come out. But if they won't come out, you can go ahead in. But there are a lot of indicia in this purported memo that would suggest this isn't a final decision. There are grammatical errors. There's not really a lot of legal analysis. In fact, the leading cases on this. One of them is Lucas versus United States out of the Eighth Circuit, and the Abel versus United States case that I referenced from the Supreme Court aren't even talked about in this memo. So this sounds more like a preliminary plan more than a final decision. But it does. It's a lot more legally valid than many lawyers think, and especially than a lot of advocates are claiming it is.
Yeah, there has been some confusion, but you explained it very clearly. Thank you very much for that.
Thank you, Don.